Welcome, everybody. Thank you for joining us for today's online talk entitled Termination of Employment and Claims for Wrongful Dismissal. My name is Aishah Rahim, and I'm an associate with Wrongful and Associates, and I will be your moderator for today's session. Before we start, allow me to play a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Before we start today's talk, let me introduce the firm and what we do. Wrongful and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 35 lawyers and a support team of T2. Datuk Ma today is a consultant with the firm following his retirement bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment of industrial relations teams, and a department focused on servicing the needs of families and individuals. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and teams, including construction, foreign direct investment, real estate, sports and esports, and ASEAN-China desk. Today's talk is part of our Ma Wing Kwai and Associates online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal advice. Our recent Ma Wing Kwai Associates online talk was held on 7th May on the topic of understanding medical negligence claims, a patient's guide to medical litigation. Please keep an eye on our upcoming Ma Wing Kwai Associates online talk. Details will be given at the end of this talk. We have two speakers for today's talk. Allow me to introduce our first speaker, Mr. Naveen Joshua Solomon. He is a senior associate in our Dispute Resolution, Employment Law, and Industrial Relations and Individuals and Families departments. He was admitted to the Malaysian Bar in April 2017, in which his areas of practice include laws on employment and industrial relations advisory, and litigation matters, as well as general litigation, which includes contractual disputes and debt recovery. Next, our second speaker is Ms. Tharani. She is an associate in our Dispute Resolution Department. She graduated with Bachelor of Laws Honours from the University of Liverpool in July 2021. and subsequently completed the bar practice course and LLM from the University of Law in 2022. She was admitted to the Malaysian bar in March 2024, and her areas of practice includes medical law, personal injury cases, and employment law. Our top points for today is the Malaysian laws on dismissal, which will be covered by our Ms. Tharani, which includes the common law's position on employment relationship, Industrial Relations Act 1967, Employment Act 1955. And the next talking points are misconduct and summary dismissal, conducting domestic inquiries, and alternatives to dismissal, which will be covered by our Mr. Naveen. Next, I will then pass the session to our Ms. Tharani.
For the first aspect of Malaysian law on dismissal, we will be looking at the common law's position on employment relationship. So an employment contract defines the contractual relationship between the employer and the employee. It contains rights and obligations of both parties. An employer can exercise termination of a contract by either giving notice as mentioned in the contract or pay the employee's salary in lieu of notice. If the contract is terminated by the employer by breaching the terms of the contract, terms and condition, which is by not giving notice or paying salary in lieu of notice, the employee then can sue for breach of contract. Further, if the notice period is not expressly mentioned in the contract, the court can then make an inference as to what would amount to a reasonable notice. So in regards to breach of employment contract, if the employee is guilty of misconduct, the employer has the right to dismiss without notice or by providing salary in lieu of notice. The employee cannot claim for damages for wounded feelings, loss of reputation, or reinstatement at common law. The only remedy available under common law is limited to damages for lack of notice. Damages are usually limited to the salary the employee would have earned during the proper notice period. If the employee could quickly have found another job, then the court may reduce the damages. So in terms of common law remedies, we will be looking at the case laws. In the case of Shell Malaysia Trading Sdn Berhad versus Satyavel 2, the court held that it will not grant a specific performance, for example, compelling reinstatement, because the court will not force an employer to continue employing a dismissed worker. This case reinforced that at common law, employment contracts are treated very differently from other contracts, since reinstatement is not available, because forcing two unwilling parties to continue a personal working relationship is seen as impractical and undesirable. So in the case of Fung Kiong Rubber Manufacturing Sdn Berhad versus Lee and Kia, the federal court held that reinstatement is not available as a remedy under common law for wrongful dismissal. At common law, if an employee is wrongfully dismissed, their remedy lies in damages for breach of contract and not reinstatement. The court reaffirmed the principle that damages for wrongful dismissal are generally limited to what the employee would have earned during the notice period or the unexpired portion of a fixed-term contract if applicable. This decision also distinguishes common law remedies from the remedies available under the Industrial Relations Act 1967. Under the Industrial Relations Act 1967, the Industrial Court may order reinstatement or compensation in lieu of reinstatement, but these are statutory remedies and not ones that are available at common law. Under common law, fixed term or task-based contracts automatically terminate upon the expiry of the agreed period or the completion of the specific task. If an employer prematurely ends a fixed term contract, either before the expiry date or the task completion, the employee may sue for breach of contract, and the employee would typically be entitled to damages. Damages in such cases would usually be calculated as salary equivalent to what the employee would have earned for the remainder of the contract period, or in other words, for the balance of his contract period. In essence, in fixed-term contracts, employees have a right to claim for loss of earnings if they are wrongfully terminated before their contract naturally ends. So for fixed-term employment contracts, the case of Celcom Malaysia Berhad versus the court held that, amongst others, fixed-term contracts can be terminated prematurely if parties contractually agreed with compensation or if the contract allows it. In this case, the contract explicitly provided for termination by either party with 3 months notice or payment in lieu, along with a table of agreed compensation for premature termination. And the court held that the respondent complied fully with this provision, including paying the claimant the agreed compensation. The next aspect we will be looking at is the Industrial Relations Act 1967 and how the law of dismissal is defined under this act. So the Industrial Relations Act 1967 regulates employer, employee, and union relations by establishing procedures for trade union recognition, collective bargaining, and the resolution of industrial disputes. It provides workers with protection against unfair dismissal under Section 20 of the Act and sets out a legal framework for conciliation, strikes, adjudication through the industrial court to maintain industrial harmony. So recently there was a major amendment to the Industrial Relations Act 1967 which came in force in January 2021. So previously under the Industrial Relations Act, the Minister of Human Resource would decide whether a case should be referred to the industrial court. However, with the amendments in place, now the minister's role is removed and the Director General can refer cases automatically to court if settlement fails. Also, with the current amendments, now the court may impose 8% interest on monetary awards, and also the claim can now continue via next of kin if the employee dies in the process of the claim. And there is also a statutory right to appeal against the industrial court's award for those who are dissatisfied with the industrial court's award. The Industrial Relations Court can also now award back wages or compensation in lieu to the next of kin of the deceased employee. The new process under Section 20 would be that any workman dismissed without just cause or excuse can file a claim under Section 20, and the claim is to be filed within 60 days of dismissal or expiry of the notice period. A representation should be filed at the nearest Director General's office, where they would attempt conciliation, and if unsuccessful, the Director General will then refer the case to the industrial court. During the process of the conciliation stage, no advocates or solicitors are allowed to represent the employee. The employees and employers can be represented by themselves or the trade union officials or any other authorized person who are not lawyers. Section 2 of the Industrial Relations Act 1967 defines a workman as employees, including those who are under probation and expatriates, who are engaged under a contract of employment, and also those who are dismissed, discharged, or retrenched workers, and anyone engaged by a contract of service instead of a contract for service, because those who are engaged under a contract for service would be recognized as independent contractors and not workers or employees. In terms of date of commencement of employment, the case of Kuala Lumpur City Security Syndrome Berhad versus Elizabeth Ling has perfectly explained this. In this case, the claimant was offered the role of finance manager and was required to report to work on the 2nd of May of 2000, but she reported on the 15th of May based on a verbal approval from the general manager and the HR due to her notice period. But when she came in to report on the 15th of May, she was informed that her offer letter was being withdrawn on the 5th of May. The court in this case held that although oral assurance were given, she had not commenced employment in that company at that point of time. Without starting work, she was not yet an employee or a workman under Section 2 of the Industrial Relations Act 1967. Thus, she had no right to file a dismissal claim under Section 20. So this case establishes that the industrial court only protects individuals who have commenced employment. The primary remedy under Industrial Relations Act is for reinstatement. So the primary remedy for wrongful dismissal is also reinstatement, and employees who feel that they were terminated and dismissed without just cause and excuse may lodge a complaint with the Director General of the Industrial Relations and request a reinstatement to their former position. However, it's important to note that reinstatement is not automatic and it's completely upon the court's discretion. However, if the industrial court finds reinstatement to be impractical, it may also order compensation in lieu of the reinstatement. What the court considered practicability is whether the working relationship between the employer and the employee can be meaningfully restored, and whether it is appropriate to, given the time lapse, the trust issues, and the employee situation, to grant reinstatement. Also includes returning to the same employment position with no loss of salary, seniority, or other employment benefits. Basically, it's putting them back to the position they were before the termination. The dismissed employee must file a claim within 60 days from either the date of the dismissal or 60 days from the expiry of the notice period if they were dismissed with a notice. The failure to comply with the time frame would result in the claim being time barred, and thus the employee would not be able to proceed to bring a claim in the industrial court. In the case of UMW Toyota, the court states that Section 20 of the Industrial Relations Act provides a quick and inexpensive remedy for employees, but the employees must adhere to the time limit as the court will not entertain late claims. Back wages in the industrial court are calculated from the date of dismissal to the date of the award. So for confirmed workers, the back wages is capped to a 24 months, while for probationers it's capped to a 12 months. The court can also consider reductions if the employee has earned alternative income during the dismissal period. Means if the court is minded to award 24 months for back wages, they can reduce it to 20 months or lower. So the calculation of back wages usually includes basic salary, potentially fixed allowances, and discretionary bonuses that are contractually guaranteed. So we will look into a few case laws for the calculation of back wages. The case of Great Eastern Mills versus King and Dr. James Alfred versus Koperasi Serbanya Berhad establishes that back wages scale down if alternative income can be proven. Further, the case of Great Eastern Mills held that scaling down back wages would not amount to mitigation, since the doctrine of mitigation has been held to have no place in industrial adjudications. While the court in Chua CG was Fuji Xerox Asia Pacific had held that since the company has been treating commissions earned by the employee as their monthly wages, the court held that the sales commissions has to be included in the calculation of back wages. So the next aspect that we will be looking at is the law of dismissal in Employment Act 1955. So we'll be looking into the Director General's power to inquire into complaints. Here, the Director General can hear and conclude on claims by an employee who falls within the definition of a worker under Section 33 of the Employment Act 1955. He can also hear and conclude claims by a contractor for labor against a contractor or a subcontractor, or an employer against his employees in respect of indemnity due to such employer under Section 13 sub 1 of the Employment Act. The Director General can also inquire and confirm or overturn any decision made by the employer under Section 14 sub 1 of the Employment Act 1955. Section 14 sub 1 of the Employment Act allows an employer to dismiss, demote, or impose a lesser punishment on an employee for misconduct, as long as there is proper inquiry conducted beforehand. In regards to procedure of the inquiry, a complainant will have to submit a written or verbal complaint to the Director General, who will examine them. The Director General will then decide whether the complaint merits an investigation or not. If it does, the Director General will then notify the person against whom the complaint has been made and will provide them details of the complaint and the hearing. Then both parties may bring witnesses. The Director General will then examine the witness. However, if any of the summoned party fails to attend, the Director General may be able to proceed in their absence, and the Director General's decision is recorded in a prescribed order and is enforceable by the court. So when it comes to employer's right under the Employment Act 1955, the burden is on the employee to prove that he did not commit any misconduct and that the termination entitles him to indemnity in lieu of notice under Section 12 of the Employment Act, and termination benefits as well. As said before, under Section 14 of the Section 14 sub 1 of the Employment Act, the employer has the right to dismiss the employee without notice, downgrade the employee, and impose lesser punishment if it is just and fit on the grounds of misconduct. Domestic inquiry, which is also recognized as due inquiry under the Employment Act, is a prerequisite before imposing punishment for employee's misconduct. It amounts to an investigation to confirm the employee committed the misconduct, but it does not necessarily require a formal domestic inquiry. In terms of what would happen if there is a failure to hold the domestic inquiry, the case of Dreamland Corporation versus Sui, the court held that the failure to conduct a domestic inquiry is not fatal to the company's case if the case is being litigated before the industrial court. This is because, as the court held in the case of Syarikat Hong Leong Assurance versus Wong Yuan Hock, breaches of natural justice can be cured in a subsequent industrial court hearing. Finally, we will be looking into the employee's right to be heard. Due inquiry includes the employee's right to respond to proposed punishments. It also states that employees must be given a fair hearing, including a chance to make a plea in mitigation. Denying the opportunity to plead in mitigation is a partial denial of due inquiry. Employees should be allowed to present arguments on both liability and penalty. Monetary limits under the law provide statutory protection for lower income workers under the arbitrary dismissal. The rule of natural justice requires no one to be punished without being heard. So in that manner, the employee has to be given the right to hear during the due inquiry process. Next, I would pass the stage to Mr. Naveen.
Thank you for the proper session and the explanation with regards to the statute. I'll take the session from here onwards by talking about misconduct. Firstly, reason why we're going into misconduct, but because this is the common termination that happens with regards to employees when they commit misconduct and the subsequent whatever that goes on later on. So I'll start by defining misconduct. It is an act or an omission to act, which violates or affects the employee's express or implied obligations to the company. It also must be related to the employee's duties and also his position as an employee of the company outside of work. And the behavior, which is a misconduct, must affect the company's image or reputation negatively. And the case which properly explains this principle is the case of Azahari Shah. As the case explains, as you see the underlined words, the relationship between the employer and employee, which is fiduciary in nature. So when a misconduct because of an act or an omission to act by the employee is inconsistent with that relationship, the act or the omission to act will then be marked, which is in bad faith. The types of misconduct that we commonly can look at with regards to the cases that have been decided by the industrial court, the most common ones with regards to tardiness, attendance, and also mannerisms at work. As you can see, the examples, I'll just state a few from the slides. The absenteeism without approval, running personal errands during work hours, disrupting others, your other colleagues in the workplace where they need to carry out their duties and your act is disrupting them from carrying out those functions. Negligence of duty at work, which effectively results in losses to the company, and insubordination, which comprises of examples like refusal to carry out your instruction from your superior. You then have the other type of misconduct where there's a blatant disregard for company safety and security measures. The important thing here is not only are you endangering yourself, but you are also endangering others by these kind of acts, whereby there is non-compliance with security measures, tampering with safety devices or machinery, disregard for safety procedures, being under the influence, it could be alcohol, drugs while at work, or falsification of records. You then have more serious ones. The previous ones were also serious, but in regards to confidentiality, which in essence is how a company runs by maintaining their confidentiality, is sharing private information about finances, business practices, and also customer details with third parties, failure to return company property when requested, damage to company property, improper usage of company IT facilities, theft, and also fraud. There are many others, but these are the ones that we have listed out. And I'm going to take you through 3 cases to see how the industrial court actually decides on a case-to-case basis. The first case of Sebastian Matthias, the employee was drunk. He misbehaved after a function in a hotel, a company function, and then he ended up sexually harassing and assaulting the staff of the hotel and also the guests. The employee argued that the incident happened after office hours and it had been personal and done on his own time. However, the industrial court decided that the dismissal was in fact done with just 2 things. That is very important note from this case is that even though it was done in his personal time, the employee had shown himself to be a staff of the company who could not be trusted to uphold the values of the company. Second, the employee had also potentially exposed the company to legal risk and to harm its reputation as well. The second case would be Mattel Tools against Anwar bin Hassan. The employee was dismissed for being drunk and misbehaving at the company's annual dinner. The dismissal was held as unfair because there was another senior manager who was also drunk and misbehaving, but he was let off with just a warning. So you see there is the impropriety with regards to how they effect the punishment towards employees. One employee was treated with a warning and one more was treated with dismissal even though they were the same offense. However, the court also went on to say that as the employee had misbehaved, the court then deducted 50% from the total amount of compensation awarded to the employee. So there are contributory factors that the industrial court will look at, as it is, after all, a court of equity. So it must be fair in its award. The last case with regards to how cases are decided in the industrial court against Pacific World Destination is Sdn Bhd. The employee here was dismissed due to insubordination with regards to the superior's order. So the employee refused to follow the instructions, and thereafter she wrote an email saying she would no longer report to that particular superior. She was dismissed. However, the industrial court had held that although found guilty of insubordination, it held that the punishment of termination was too harsh a penalty. So this is where the doctrine of proportionality comes as well. Whether, first, there is a misconduct, and second, whether the misconduct warrants a dismissal. So that's one of the more important elements. And also the court went on to hold that the single act of insubordination and the first misconduct in the employee's 20 years of service should not have warranted a dismissal. So the service, the tenure is also considered by the industrial court. We then move on. So after you have identified the misconduct and you've seen which category to put it, whether it's under gross misconduct or normal misconduct, you have to then decide whether you are going to terminate the employee by giving them notice period, by either paying them salary in lieu of notice, or you ask them to carry out their task throughout the notice period, to serve the notice period. And the second one is whether to summarily dismiss them. So I'll take you through summary dismissal. It's an immediate dismissal without any notice and without payment. And the most important thing to note here, the burden is on the employer to prove that not only the dismissal was with just cause, whether it warranted an immediate or summary dismissal. As the dismissal must be justified based on facts. The telecom case is very clear for HR practitioners and IR practitioners. The standard of proof, even though you have misconducts, maybe there's some element or criminal element in it, but the industrial court is going to decide it based on the standard of proof with regards to the balance of probabilities, where it's more of whether the likelihood is there, whether the employee has committed that particular misconduct. So grounds for summary dismissal, of course, the Employment Act provides summary dismissal. However, it is not very clear as to what kind of misconducts actually warrant summary dismissal. But throughout cases that have been decided by the industrial court, it's always in regards to more or less this four. Of course, this list is not exhaustive. It includes gross misconduct, which includes dishonesty, cheating, breach of trust, criminal behavior, which includes but not limited to theft, sexual harassment, briberies, and also serious insubordination. For acts outside the scope of employment, as you had seen in the earlier case of Sebastian, whether it would affect the employee's ability to perform duties or even affect the employer's reputation. Case laws that we can have a look at with regards to summary dismissal. We can have for the first case, the Malaysian airline system against Rizryan Abdul Rashid. The court held that although the claimant's dismissal were based on circumstantial evidence, it was strong enough to point to their guilt. So in this case, the first charge was that the claimant had issued credit card charge forms for sales that never actually occurred in flight. And the second charge was that claimant had submitted sales under names of passengers who were not even on the flight. So these were all proof. Of course, it didn't point conclusively, but there were other circumstantial evidence as well. And as I told you earlier, it is more on a balance of probabilities. So the conduct of the claimants here was a breach of the company's guidelines and tantamount to an act of fraud. So it justified summary dismissal. We then look at the case of Aminuddin Baki against Sabtu Esa. The claimant here was the CEO of the company, and there was proof of misappropriation of funds amounting to 1.7 million through fraudulent procurement. So it involved the case of criminal breach of trust, and the court held that the prosecution need not prove the exact mode of misappropriation. And this sentence actually is quite important. As long as it shows that the accused was entrusted with property and honestly failed to account for it, it breaches an obligation. And given the claimant's position, senior position being the CEO, it is of utmost importance that trust needs to be going both ways. You have then the case of Samba Murali Krishna. This is a sexual harassment case. He was also summarily dismissed, and proofs and the evidence given by the company witness one were all consistent. Unfortunately, the claimant was not consistent in the evidence that he had given, and therefore the court found that the claimant's conduct had clearly breached his fiduciary relationship with the company. And you go on then to the next case of Muhammad Zamani Ibrahim. Here, it was a clear case of insubordination. The claimant refused to adhere to the instructions given by his superior, and he just went back to his place and not wanting to carry out any work, and therefore he was then terminated. So with regards to misconduct summary dismissals, you then have to make sure it is of utmost importance that the reasons that the employers are relying on to terminate the employee has to be stated in the dismissal letter of termination. The relevant ones are only reasons stated during the dismissal by way of the letter. So it's important to also note that the grounds that are relied upon by employers which are not mentioned, it will not be considered as genuine and it will be regarded as afterthought. Valid reasons or grounds that the employer was aware of but not mentioned will not be considered by the court. You can see it in these cases where employers are bound by the reasons in the dismissal letter. The principles in Gunpei was further then enunciated in the case of maritime intelligence. Two important things is that firstly, the federal court, this is a federal court case, it held that post-dismissal discoveries cannot be used to justify the dismissal. So the reasoning behind this is that the reasons for the dismissal, it must be ones which are operating in the mind of the employer during the time of the dismissal. So if it is operating in the mind of the employer, it has to be written down in the letter of termination. So that is why it's very important to state the reason of the termination in the dismissal letter. Do not rush it. Be dealing with it, you have to be tactful and also proper. However, post-dismissal discoveries, although not stated in the letter, it can be put into your pleadings because it may be relevant to the courts which are deciding it in regards to the terms in the assessment of compensation and also remedies. So then with regards to misconduct, of course, the common notion is that it's not fatal if you don't have a domestic inquiry because it then goes to the industrial court and the industrial court will proceed to hear it de novo. So I'll just go through briefly with regards to the process for a domestic inquiry because it's always good practice to have this, especially if it's relating to gross misconduct. So as Section 14 sub 1 provides for due inquiry. Of course, due inquiry can also be show cause letters, not necessarily domestic inquiries, but the most important part for due inquiry is that an employer provides the details of the misconduct and the employee provides an explanation that is amounting to due inquiry. It's properly illustrated in the case of Gianna Sina. A domestic inquiry is part of an internal process conducted by an employer to investigate. The Employment Act states that an employer can only punish the employee if they conducted due inquiry. So punishment only can come after due inquiry. Employers should not jump the gun by punishing right after they hear about it. You have to conduct due inquiry. You have to get the explanation. The Act does not define what is due inquiry, but the case laws have suggested that even show cause letters amount to due inquiry. But the most important thing is that employers must investigate the matter fairly. In some cases, even discussing with the employee in question can also be considered as due inquiry. That's why I say it's a two-way street. The information has to go and the explanation has to come. So in regards to before you carry out a domestic inquiry, there are two types of suspension. The pre-inquiry suspension allowed under Section 14 sub 2, the Employment Act, for a maximum of 2 weeks with at least half wages. You have then post-inquiry punishment limited to 2 weeks without wages under Section 14 sub 1C. The nature of suspension, it is to enable a fair investigation. So while the employee is on suspension, his duties, only the primary job duties are suspended. He's still entitled to the benefits. However, he must be always available for investigation. Any leaves, travels, or work elsewhere without approval cannot be done. It has to be done with approval, and he should not be able to access company files or premises. This access can be granted when he is called in for an inquiry, then he'll be allowed to access whatever necessary in order to explain any details with regards to the charge. The show cause letter is to give the employee a chance to explain allegations before formal charges. It's very important that the show cause letter contains specific and a detailed date, time, and nature of misconduct. This is very important. There are many cases where the charges have been defective because it is not detailed enough. And then the claimant gets to the dismissal will be upheld as without just cause and excuse. The best practice to allow an employee to reply, of course, the best case scenario is 14 days. It depends on the amount of charges and the amount of time required to reply to those charges. If it's a lengthy show cause letter, you obviously need to give at least 7 working days, but 14 working days would be all right as well. As I said earlier, poorly drafted or vague letters can void the dismissal. It's illustrated in the case of SO production. Procedure for domestic inquiries, the formation of panel, at least 3 impartial members. They must be of higher rank and they must not be involved in the investigation to ensure there's no biasness. The employee should be allowed to enter his plea and given an opportunity to defend himself. However, for employees with a union, they can also have the union rep present during the inquiry. With regards to documentation of the domestic inquiry procedures, notes of the DI should be taken down in verbatim. Transcripts should be signed by the witness. Findings by the panel should be in writing and submitted to the management. It's important to note that panels should not be making recommendations in respect of the punishment. It's only the findings, because any decision should be made by the management based on the findings of the panel. The guidelines and best practices, the charges should be drafted precisely. Panel members should not be the investigating officers or the prosecuting officers. Their right to be heard, the employee should be given full opportunity to present his case. As long as given the opportunity to present his case, to allow him to explain his arguments and it is captured, that is very important. Panel members may also ask clarifying questions during the proceedings. Panel members should and must consider and analyze all available facts and evidence before finding out whether the employee is guilty or not. So in short, for domestic inquiry, the domestic inquiry is a search for truth, facts, circumstances. It is an inquiry created by the management. It begins after the issuance of the show cause letter, and once the response is unsatisfactory, especially with regards to gross misconducts and breach of duties, especially fiduciary duties, employer can commence domestic inquiry. It is merely a fact-finding exercise, and again I stress, it does not decide on the disciplinary action or punishment to be taken against the employee. That is with the management of the company. So alternatives to dismissal, when you think about misconduct and whether you want to summarily dismiss them, and then the practice of domestic inquiry, and where the management gets the findings from the panel, they have to make a decision. So in addition or in alternative to dismissals, these are the things that the management can consider as well. A warning letter, okay, it's appropriate in cases of less serious misconducts with regards to absenteeism or late coming, and it's important to be documented. Verbal warnings, when it goes to industrial court, it's always a he say, she say situation. So it depends. It's always important to document warnings, okay? And in this case, Japanese Cooperative Society, the High Court held that past warnings were relevant and cannot be considered as spent. You also have transfer. So the one thing with regards to transfer, of course, the how do you do it and everything is there. But one of the more important things that the industrial court takes into consideration is that the transfer must be done in good faith. So when someone is maybe accused of a misconduct and then the decision to transfer them, if it is someone who is from Klang Valley and you give them 2 weeks to relocate to Kedah, employee might then say that he's being constructively dismissed or being forced to resign because you're not giving him the time to in fact transfer out. So it's always important to remember, do not make it look like as though the employer is acting with an ulterior motive. You have other alternatives as well. You have suspensions, you have demotions, you have withholding increments or annual bonuses. You see, these are all prerogatives of the management of the company. They have the discretion to do this. You have fines as well. So before I end my session, I think it's important for me to explain on this particular principle, which is the doctrine of condonation. An overview: condonation occurs when an employer, with full knowledge, that means the employer must have had knowledge of the employee's misconduct, chooses to keep the employee. Okay, the second point also goes to awareness, because in order for the condonation to apply, employer must have complete awareness of the misconduct. So when they choose to ignore the misconducts that have occurred and not punishing, the employer is essentially waiving the right to punish the employee. Condonation can be expressed through direct forgiveness or implied by inaction. So that's why the most common thing that employers are caught by is the implied by inaction. Because when the employer does not punish the employee at all for the particular misconduct, and suddenly after 3 or 4 years, you start to dig out all the past same related offenses, then you want to put it into your show cause letter. That's where condonation can apply as a shield for the employee. One of the cases that we looked earlier is Ryan. The claimant wished to rely on the principle of condonation, must expressly plead the same in his or her pleadings. However, where if the issue of condonation is raised during only the trial and it's without objection, even though it was not pleaded, the court will allow the issue of condonation to be raised, provided there is no objection. So if you wish to object to the issue of condonation being raised the first time during trial, please do object it and raise it during submissions as well, that you have objected. You have cases on condonation as well. So I'll just explain briefly. The 3 cases, essentially, they explain that once an employer has condoned a particular misconduct, they cannot go back. Okay, has to have full knowledge. If you look at the case of Azlan, the industrial court dismissed the claimant's claim against the company because there was no evidence that the company had full knowledge. So that's why the company must have had knowledge of the wrongdoings. And a delay also under the case of Bui Kim Lee, a delay of approximately 1 month in commencing disciplinary action was held by the High Court as not constituting condonation. It's just this one last case that we want to look at is this Court of Appeal. So in this case, the Court of Appeal held that the concept of condonation only applies when the employee wants to use it against the employer. Okay, it does not apply when the employer wants to use it against the employee. The company cannot use it against the employee. Okay, I'll just explain that the concept of condonation it functions as a shield for an employee. Okay, so the concept of condonation should not be confused with waiver. So if the company terminates an employee for offenses that have occurred regularly, the claimant or the employee can then claim condonation by saying that it has been going on, the company had knowledge of it, but they still kept quiet. That is available to the employee. If an employer, the company, has breached any terms of the contract and it's been going on for a while, the employer cannot claim that it's being condoned by the employee. What the employer can do, what the company can do is that they can say that it's a waiver. The employee has waived his rights to claim against the breaches by the company. So we must not confuse condonation with waiver of rights. So with that, thank you very much. I'll pass the session back to Aishah.
Thank you to our speakers, Ms. Tharani and Mr. Naveen, for their insightful termination of employment and claims for wrongful dismissal. So now we've seen that there are a few questions from the audience. So for the first question, we have one from Ms. Vita Silva, where she asks, in fixed-term contracts, if the employee has performance issue and opportunity to improve has been given, yet the employee does not perform, can the employer then terminate? I believe our Mr. Naveen will take this question.
The first question with regards to in fixed term contract, if the employer has performance issue and opportunity to improve, but yet it does not perform, can the employer terminate? So I think the first thing to be addressed here is that in a fixed term contract, as the name suggests, it is for a fixed term. It depends on the period of the fixed term contract. If performance is something that worries the employer, such a clause should be specified in the fixed term contract itself. Because in the event that the employee is dismissed before the end of the fixed term contract, then the employee can claim for the remaining period of the fixed term contract. But to answer the question, for probationers, of course, it applies the same as well.
Thank you, Naveen. We'll then move on to our next question. Also from one Ms. Gita, which is asked whether notice period is provided in the Employment Act. Does the said notice period applies to employees under probation? Ms. Tharani, would you like to answer this question?
Yes, okay. So the notice period in the Employment Act 1955 is the minimum provided, and anything below this, it may run afoul of the prevailing labour laws. As for the question, yes, it does apply to employees under probation as well.
Thank you, Tharani. Our third question is from Anonymous. So they ask, is domestic inquiry required to dismiss an employee who is still under probation? So can the employer just dismiss the employee because of not suitable for the job? And I believe this question is similar to a question by Rachel Tan, where she also asked more or less a similar question. Can we have our Miss Tharani to answer this?
Okay, I will answer both questions together since both questions are similar. A domestic inquiry is not legally required to dismiss a probationer, but the dismissal must still be made in good faith and not arbitrarily. This is because probationers are still employees and they also enjoy the same legal protections as other employees. An employer can dismiss a probationer for being unsuitable for the job, but they must be able to show that the decision was based on objective reasons such as performance and conduct.
Thank you, Tharani. We have our next question from Anonymous. They ask whether there is a time limit to file a complaint to industrial court. If so, is there any legal recourse for the employee and any time limit for pursuing legal action? Can we have our Mr. Naveen to take this question?
Okay, with regards to time limit, unfortunately, the 60-day time limit is mandatory. There have been cases where there has been judicial reviews to review the decision of the IR department to accept the complaint when it's filed beyond the 60 days. Unfortunately, it was not allowed. The judicial review was not allowed. So 60 days, it starts from the last day the employee is with the company. Okay? In the event that the employee is paid salary in lieu of notice, it starts from the date that the last date. You essentially always take the last date that the employee has worked with the company. Yeah, thank you.
Okay, thank you, Mr. Naveen. Then we have another question, anonymous question, and they ask, does dismissal due to poor performance with no element of insubordination but pure incompetence would be categorized as misconduct? Goes through misconduct do improbably frame as breach of fiduciary duty and be dismissed as such. If indeed poor performance could be deemed a misconduct and be dismissed as such, does that mean the employer would not have to pay termination benefits? Ms. Tharani, could we have you answer this question?
Okay, poor performance is not a misconduct and should not be disguised as one. It must be handled through proper procedures like warnings and giving them chance to improve. However, if they are dismissed for poor performance with just the cause, then the employee may not be entitled to termination benefits. However, misclassifying poor performance as misconduct can lead to a finding of unfair dismissal by the court.
Thank you, Tharani. Then we will have our last question in view of a time constraint. This question comes from one Tira Singh and is asked specifically to our Mr. Naveen. Is there a specific time period to define condonation by an employer?
Yeah, thank you for the question. With regards to a specific time period for condonation, as you have seen in the case that I mentioned lastly earlier, the second last slide, even a period of 1 month did not amount to condonation. So I believe the approach that should be taken by the company, it should be a reasonable time period. I can't give a definite time period, but if you're talking about more than 6 months, that would be unreasonable. But again, like I said, the importance is the full awareness of the company. If the company had knowledge from the beginning itself, then it would be difficult if you're going past 6 months. But if it was just in between that the company found out, then the company can justify in court. But what I can say is, based on cases that are coming and for advice, is that sometimes they jump the gun by actually the first offense comes, but then they start to dig in and they try to look in for other mistakes to tie it up to this. So that's where condonation often is raised as a shield by the employees. So try to be alert with regards to what are the things that are being committed by your employees. I know sometimes it's difficult because you have a lot of employees and it's difficult to safeguard each one of them. But that is why we need to have a proper HR team and also people advising with regards to employment and industrial relation matters. Yeah. So thank you. I know there are quite a bit of questions, but do reach out to us after this session. Drop us an email if there's anything that you would like any clarification regarding. Thank you.
Thank you once again to Mr. Naveen and Ms. Tharani for your insightful sharings and for taking the questions from the audience. So now I will have a few announcements. First, please join us once again for our upcoming talk, which will take place on the 11th of June 2025 on the entitled Common Property Disputes, Recovering or Defending Ownership Claims, and our speaker will be our Ms. Kirbashi. And on the 18th June 2025, we will also have our talk by our Sharia team, Understanding Your Options Under Sharia, Estate Planning, specifically Wasiat and Hibah. Our presenters will be Ms. Anis Muhammad Sohaimi and Ms. Miro. And on 25th June 2025, we have a talk by our Ms. Agalia J. Munasami and Kirtika Padmanapan on the title of Cryptocurrency and Anti-Money Laundering Risk Trends in Malaysia. So you can sign up for more of our online talks by scanning the QR code on the screen, as well as going to the link provided here. Also, we are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, as what our Mr. Navi had said previously, we do offer a complimentary 30-minute consultation over the telephone or our video conference. Please fill in the form on our website. The QR code and the link is posted on the screen. So with that, thank you to our guests. Thank you for joining us. We hope you have a very insightful sharing of today's session and very informative and very useful. We hope to see you again on our next talk.